Hey everybody, good morning. I'm JD Hoovener, the host of the Bold Patents Show. You've made it here. We're live every Wednesday, 9 a.m. Pacific and noon on the East Coast. I'm here with Matt Kolseth. Matt, good morning.
Morning, JD. How are you?
Doing good, doing good. So glad to have this show keep on going here. And we can see the sun hitting my face. We're into spring, my friend. And the the topic I picked today was spring cleaning. It's on my mind. We've got a lot of dust building up, a lot of the winter clutter still out. How about you? Do you guys have some spring cleaning to do?
It's still winter here in Minnesota. It just snowed last night, so this
Okay.
is sunshine. This is a light.
Right. Oh, okay. All right. All right. So you're still fighting through some of that. Got it. Well, good. Well, I think it's still top of mind. I think for most of America, we're starting to kind of wake up, appreciate some better weather. We're actually having a bit of a cold snap too. But with that comes, this sort of idea that we're trying to clean up, trying to make our job easy as possible, and without, breaking your back. And it's a great, I think, example of the way that most anyone can be an inventor and should be thinking about creative solutions all day. And not have to move forward with the patent right away, but it's something to begin your just to break the mold, right? The daily rhythm of just going through and assuming, that you have to use the can opener or they have to use the broom, the standard bristles that are clogged up with dust, or how else could it be done, right? And here comes the Swiffer, right, dominating the market with a new innovative product. So I've got a couple. One example on our coming up on our Bold Bites that we're going to get to. And as always, we'll be featuring any live questions that have come through. I've gotten a few that were already pre-submitted, and we can just jump right to those, Matt, unless you had anything on your mind you want to talk about.
No. I would just say that, we've got the opportunity to work with lots of clients who are kind of in that cleaning industry. And when I think of cleaning, I think of, both services and product. You obviously have like chemicals, you have like the apparatus that applies the cleaning solutions, that sort of thing. So there's lots of different ways that we've registered clients' trademarks in this field. So that's something we can kind of chat about a little bit later too.
Yeah, that sounds really good. I think some of these questions will be right on point too. Let's start with a trademark question. We had 4 trademark questions submitted. This one's out of Chicago, Illinois, pretty close to where you're at.
Yeah, but hours for me.
All right, this is a question about licensing.
Okay.
Let's see what we get to. I'll put this in the chat here for everyone to look at. All right. I want to start an online business. I want to be selling tea and coffee blends with the option to add CBD oil. Weed is legal here in Illinois. What licenses do I need beside an LLC to sell my product?
Oh, interesting. All right. So I won't be able to comment too much on Illinois licensing. That's, I'm a Minnesota attorney. I barely know anything about Minnesota law since I practice federal trademark law, for 99.9% of what I do. But so you'll definitely want to get in touch with a business attorney in Illinois who can kind of help you with like the licensure requirements. What I can tell you about though is that, well, I guess let's talk a little bit about filing trademarks for coffee and tea at the USPTO and like the implications for CBD. So coffee and tea, like a lot of things, we've gotten to work with lots of clients in coffee and tea as well. It's class 30 at the USPTO. It's one of 45 classes, and specifically it's class 30, which basically allows us to register the product itself, not necessarily the online retail store services or anything like that, but class 30 is where you would fit. In terms of you'd want to register in class 30, CBD is basically, it's like the third rail of the USPTO right now. Years ago, they were letting us register it, and now they're not. So my advice for most clients today is that we don't, if the product has CBD in it, we're not necessarily disclosing that to the USPTO and asking for protection for the CBD components of the product. If they ask about it, obviously we have to disclose it, but for the most part, it's not something that we're necessarily pushing our clients to do.
What's the rationale on that, Matt? Have they said anything as to why they're holding it?
Yeah, it's kind of curious. I mean, it's like this like back and forth thing, like through the Trump years, and now with Biden, things haven't changed too much. But what I would tell you is that at first, it didn't seem like the USPTO was going to enforce the Controlled Substances Act against CBD. And then they basically cited the CSA against applications, thousands of applications that contain CBD. But the way around it via the Farm Bill was to say that the CBD had less than 0.03% THC.
Right. I remember that.
And the USPTO said, okay, that's great. And then now they're basically holding up every single application, regardless of the THC content of the CBD. It's a mess.
Interesting. Oh, all right. But I wonder if there was like some pending case that's waiting to settle or be decided with respect to that 0.3. If somebody's challenging, maybe you can get a psychedelic effect, below 0.3 or something. I don't know. I don't like the psychedelic, but some sort of a,
we just need the Biden administration to make a recommendation to the USPTO. And, right now, what we're doing for clients is just delaying the examinations of their applications because they're getting office actions, and we're basically trying to suspend our applications, hoping that something changes at the USPTO, like it's done in the past. I mean, this has been just this bouncy ball for the last 3 years. So yeah, we've had clients early process get through, later clients got denied, and existing clients right now we're just basically treading water, hoping something changes.
Okay. Well, thanks for that answer. Yeah. So yeah, again, just to recap, for questions about local licensure and LLC, we would recommend you back to that business attorney within your own state. But thank you, Matt, for that awesome example on CBD and the idea about registering coffee and goods and products.
Yep.
Let's do one more for you on trademark side, since we're at it. And actually, this is Spokane, Washington, which is only about 100 miles from where I'm at in Moses Lake, Washington. So pretty cool local example here. What's the fastest and easiest way to get my trademark registered for a statement of use? I need to get my trademark registered for my consulting business. However, I still have not applied for a statement of use because I have not started advertising yet. I could use some help with filling out and submitting my application to get my trademark registered with the USPTO. Matt, any high-level suggestions? Consulting business.
Yeah, consulting business, class 35. JD and I know something about that too. So yeah, in terms of filing a statement of use, what they're talking about really is, it seems like maybe they have an application at the USPTO that's intent to use, meaning that they're asking the government for some preliminary approval before they go to market. And that's a way that if you're not in the marketplace today, you can actually speed up your examination procedure, because when you do go to market, typically you can get your registration then, if the government's approved your application, within 4 months. So you can basically knock off 8 months of registration time if you apply early, which is great. But once you file your statement of use, it's just a waiting game, right? So once you file the statement of use, typically it's going to be 3 to 4 months before you get your registration, assuming everything else went through the process. So there's no quicker way to get that statement of use filed. What he might be or she might be asking about is they're looking for potential use and they don't have it yet. What can qualify as use? So what I would say is, for a service like consulting, you don't actually need to sell anything yet to be in use. Meaning that even if you have just a website up that is, offering services for sale, that constitutes use. So you don't need to have, an actual, sale in order to be in use.
Perfect. Yeah, and this is the last part of their question. They have a website, they're still working on it, and it's not ready to publish. But you're saying a website offering those services would actually work in most cases.
Correct.
Cool. So they're really close. Very good.
Very close. Get that website published. It doesn't have to be fancy. It basically just has to say who you are, the services you offer, and how to contact you.
Is it true you actually have to take money, or could they, as they suggest, volunteer services? Would that still count if you're doing it for free?
Yeah.
All right.
But, they don't have to. They just have to offer the services, right?
Yeah. Perfect. Well, that's good stuff. Let's do this. Let's jump to patents here, and then we'll do one patent question, and we'll go to our bold bite segment. If anybody has any questions or thoughts about cleaning products, maybe something you've come up with or thought about and you want to just float, be happy to chat about that a little bit at a high level. Obviously, don't disclose anything confidential here in this forum. Let me go to our question here. Yeah, it's awesome. We did get quite a few questions this week. People are thinking.
Yeah,
Let's
JD,
see here.
I'm thinking of a client that we recently worked with on the cleaning side of things, and they have a cleaning product. And I just remember this, but this cleaning product, they got an office action for likelihood of confusion with a previously registered trademark, but it was kind of a different product, right? So like maybe our client was like in like cleaning solutions, and this client was like specific like a toilet bowl cleaner, or like the other party was like a dish cleaning product. It's a really good trademark, like really good. Like I was really surprised that we were able to do it, but we did get it. So
cool.
Yeah.
Can you share the name? Did you remember?
What's that?
Do you remember the name or the mark?
Am I allowed to disclose it?
Well, is it published? Well, look, if there's any question, let's hold off. But no, it's good to have that example.
Yeah.
Maybe we can come back next week and share. All right, so this is a question for me, if I can handle it. Let's see. Hi, I've developed a system that I use to trade Forex. Okay, this is foreign to me a little bit, but I need to protect it from being copied. I want to make this into an automatic trading robot, which is called an EA, expert advisor. I have an MT4 coder, from the Ukraine. All right, I hope they're doing well there. Bless them. But I don't trust him not to keep the robot to himself once completed, or he might try to sell it himself. How do I protect myself? If I use a coder from the US, how would I protect myself? Okay, so quite a bit going on there. A good chunk of that is sort of not necessarily patent related, but I will sort of give my thoughts on hiring and contracting overseas. What comes to mind right away is disclosure and trade secrets. So it really comes down to how close, what's your risk tolerance for potentially having information be leaked or a confidentiality agreement be breached. The best way to have and keep an employment agreement or a contract or a third party like your coder, that information confidential, is to have it be very local, right? Someone who you can touch and see and feel and like sit kneecap to kneecap with, and have it be enforceable within your own state. A little bit less, more risky, I should say, would be out of state. And then the most risky is out of the country. So in this case, in order for that, let's say you have in a contract, assuming you went that far and tried to be, get something binding. In this case, if that coder were just, to go off the rails and to create their own or to take it from you, you're now gonna have to go into a foreign country, Ukraine in this situation, which has its own issues, legally. But you're gonna have to go try to enforce it in a foreign court. So that's really dangerous. It is quite risky. So be very careful when you have a third party, and try to use the best contracts you can. Not a contract law attorney, just say I would be able to refer you to someone here in the US. I might be able to extend that and offer you some services overseas. With respect to coming up with a novel robot, a trading robot, if you've got a process or a system, a function that robot performs, software is just the mode of performing that step, right? That series of steps. If those steps are unique and they provide a functionality that has a benefit and a utility, it's patent eligible. So it's wonderful. I think you should explore that. I'm going to provide a link here at the end of our session for you to take a 15-minute break from your day and visit with one of our advisors to see if now is the right time to take action and protect that invention. So it's worthwhile taking a look. I think if you're investing a lot of money into it and have a lot of energy and you're worried about someone taking it, it's likely got some energy and some real value. So I think it's worthwhile spending some time letting us take a look at it and see if it's worth protecting. Matt, any thoughts on that from your end?
No, I think you hit it out of the ballpark. I would just say that I deal with our entrepreneurs dealing with foreign manufacturers all the time, not necessarily on the software side of things, but on the product side. And your analysis is spot on. I mean, anytime you go overseas with a product, or a development project, you're at risk. You're at risk. But unfortunately, that's where a lot of talent is. That's where a lot of manufacturing is. And you just have to, try to mitigate that risk, work with people who have a reputation for integrity, and hope for the best.
Totally. Yep. Well, I wish that question asker the very best. Follow up with me. What I'll do is I'll put our information here. If you want to confidentially reach out via email at this point. And then we're going to go to our Bold Bite segment here on cleaning products. So this is what I'm going to share screen on. And Matt, am I coming through volume-wise?
Yeah, loud and clear.
Okay. Oh, I've got to, let's see. System preferences, hang on. We got to go in here. It's the good and the bad about Apple. They're quite particular about what you give access to. All right. And we got camera and screen sharing. Oh man, okay. Okay, let's try it again. Oh, that's a bummer. Okay, and then we'll try last time. Window. Oh, it's not going to work, Matt.
Okay.
That's okay.
I mean, I'm a little disappointed, and I'm sure.
I know. I had a good one here. I mean, let's just take one more minute.
Sure. And while you're working on that, I can kind of explain a little bit about what Bold Bites is. So Bold Bites is basically an opportunity for JD and I to comment on intellectual property that's being discussed on Shark Tank, right? So we have people pitching on Shark Tank, and then we kind of analyze the invention or the product or the idea from an IP perspective and kind of give some context for how we might go about protecting that invention or helping the client develop it.
Okay, I'll be right back, Matt. I want to try this.
All right, so we'll just wait for JD here. And if anyone has any questions, feel free to throw them in the chat bar and we can get to them as well. Yeah, and we're happy to kind of work with you and figure out a time to get together and chat about your invention, your product or service. While JD is coming back to the show here, I can tell you a little bit about me and what I do. So I'm a trademark attorney, and I've been practicing law for 11 years. Work with clients all over the country who are, either in business or bring products and services to market. I live in Minneapolis, and most of my clients are actually not from Minnesota. The vast majority are from California, Texas, New York. I'd say probably only 10% of my clients these days are actually in Minnesota. We've been a virtual law firm since the beginning, which is kind of new to a lot of firms, but not new to us. Hey, JD, you back?
Hey, yeah, you're able to keep going. That's amazing technology right there. I thought for sure to shut it down. And we're sharing. Okay,
yeah.
So we've got a cleaning product here. I'm going to share this. Thanks for hanging in, everybody. And this is our Bold Bite.
This is what an average household uses in 1 year in cleaning products. This is such a waste.
I decided to really cut back on my own personal consumption of single-use plastic. Blueland doesn't use any single-use plastic packaging, from our bottles to our tablet wrappers to our shipping boxes.
Our tablets are smaller than a full bottle of conventional cleaner.
And oftentimes, when you buy these products, they're over 90% water, which you already have at home practically for free.
Our tablets start at just $2.
It's a cheaper alternative to going out and buying a fully plastic bottle of cleaner. Blueland is sold as a refillable, reusable system that actually saves you money in the near term.
All right. So what do you think of that, Matt?
Yeah, I I love the idea. I don't necessarily think it's novel.
I wasn't thinking that either. I wasn't sure. Yeah, it's like, all right, yeah, it looked kind of like an aqua seltzer.
Right. Yeah. I've worked with clients who have used similar products in their own cleaning products in the past.
Okay.
The client that I'm specifically thinking of was leveraging a similar, like, bring it home, like dissolve it in products, in water basically, and then he had a unique method of dispensing the product. That's what his invention was. The idea of having a tablet and dissolving it for whatever, for cleaning purposes, doesn't seem novel to me. What about you?
No, I don't know. I have to see what it's formulated by, and I wondered, can it actually clean? What are the compositions there? My mind goes toward composition of matter, which is one of the major categories under utility patents. If they put together for the first time ingredients into a solid like that, which I highly doubt. It depends on what it is. They could potentially get a composition of matter claim, which would be super powerful. I think it's more likely that those are not uncommon elements, that they're pretty standard, whatever it is, soaps or basic solutions that are cleaning agents that have been used for years. What might be novel is this potential size of it, and maybe the shape of the tablet. Those are ways I'm thinking, hey, we can try to look for any little bit of novelty to try to get them some protection. This type of a system and product, it looks nice and polished, right? It's a good example of you don't necessarily have to be novel in terms of what it does to be successful in the market.
Right.
You can still look for little ways, like I mentioned, the shape of that little pill or the bottle, or perhaps even the amount of or the method of mixing, and you could try to go for a little bit of novelty there, but it seems pretty thin.
Yeah. What I would say from like a trademark perspective too is that I just looked them up, Blueland.
Right.
They are registered. They do have trademark registrations in the cleaning class, as well as basically like the cleaning towel class. And let me see if there's anything else. They're in laundry products as well. And they actually have some registration for disinfectant soaps. So they're well covered. I don't see one for their online retail store, which is surprising. Should probably talk to an attorney about that. But anyway, what I would say about their brand is, it's conceptually registrable, but I don't necessarily know what Blueland is. So from just a consumer standpoint, if you tell me your brand is called Blueland, I don't really know what that means, right? It's not highly suggestive of a product that cleans or anything like that. So I don't know. It's registrable, yeah, but is it a great brand? I don't necessarily think so, because I can't even tell you where this product would fit into the whole scope of products and services in the world, right?
Yeah, when I heard Blueland, I'm thinking of, that's kind of the umbrella. That's kind of like the Procter and Gamble. But what's this product? What's going to make me remember it to be able to tell a friend of mine, oh yeah, go buy Blueland? It's got to have something more catchy, And
that's a good point, JD. And like we talk with clients a lot about this, is that, is your product the same thing? Is it the same name as your company? Right? Is your product the same as the larger company, right? Or do you have different names for each of your products? Because oftentimes what we see, and we were talking about this at the hardware show last week with a potential client, is that you have your kind of hero product that you go to market with, and you name the business or the website the same thing as the product, right? Well, what happens when you need to add a second product, right? All of a sudden, do you need to have a different website? Or, so clients need to think about how they, portray their brand in relation to their products. Because if you add second, third products, all of a sudden you have to come up with different names for each of them, and it's very confusing for consumers.
You bet. No, that's awesome. It's a really good point. I'm thinking about that for myself, being selfish here. I've started Bold Tax and now Bold Connections and Bold Consulting. Have I made mistakes there, right? Maybe I need to kind of reevaluate where we're at in terms of our Bold branding. But certainly we are. It's the same people, a lot of the same culture. On the services side, I think it's easier. We get a little bit of a break. But on the product side, you're right. They're so different. If you're offering different products, it could be a big slip if you don't plan it out ahead of time. So any of you out there thinking about launching products, want to know how they fold into businesses, I encourage you to reach out to Matt. I provided our emails up above or just on the comments there, matt@boldip.com. I'm jd@boldip.com if you have any patent questions. I'm going to put in our link right now for those that have been hanging online and waiting, how do I take action? This is how you do it. We provide a special link. This is our weekly live. And so this is your ticket to a free 15-minute session with one of our advisors and a free copy of Bold Ideas, The Inventor's Guide to Patents, that book I wrote just a few years ago. And we're going to be giving you the second edition, which just got published this year, Matt, which covers some of the new examples from our medical device and our example in the dentistry, which is exciting. So book your 15-minute free appointment today. We've got time for maybe one more question. Are you up for one more on trademark, Matt?
Oh, yeah, of course.
All right, let's do it. And again, if anybody's in live questions, you've got a few minutes to get it in. So this is your time. We'll look for that. All right. Oh, this is on the patent side. Let me go back over to trademarks. I put Matt on the spot. Okay.
Yeah.
What's that?
Patent question, you're going to get a bad answer.
You want a Springfield, Missouri, or Eagle Mountain, Utah?
Ooh, let's go to Utah.
We're going to Utah. All right, and this is about hot dogs. Here we go.
Okay.
I love this. Someone's got a hot dog restaurant.
Sweet.
Okay. This could be like an example, I feel like, in one of our presentations, Matt. Here we go. Can I name my hot dog restaurant after a literary character like Scooby, Cujo, or Beethoven? Example, Cujo's hot dog, I don't know what that is, opening a small hot dog cart that will be set up at local events and farmers markets. What do you think? Oh, hut. Cujo's hot dog hut. There we go. What do you think? Do you like it? Are they in trouble?
Do not use Scooby.
Okay.
So this is a hard one.
Mm-hmm.
So historical figures, yes, potentially. Like Beethoven, potentially could be okay.
Meaning okay, all right, okay.
But like Scooby and those literary characters that are still protected by potentially copyright, don't go anywhere near them. So you can actually have, this is kind of interesting, but you can actually have trademark rights to basically characters if they're sufficiently delineated. So it's not necessarily that, yeah. So basically, like the company that owns Scooby, I don't know who they are, Scooby-Doo, right? They're going to claim broad rights to basically everything under the sun, right? And if you're making a connection, what they would say was a false connection to the brand using Scooby on your hot dog truck, you're going to get a cease and desist, guaranteed. Historical figures, not so much. You're not going to have a problem with that, unless they're closely associated with living relatives. But just the same, you can't necessarily protect that type of brand from third parties. So, yeah, we should talk.
That's tough, Matt. What if they, the owner here actually has a dog and they've named the dog Cujo? But you're saying because it's a nearly famous literary character, the copyright owner.
Well, is Cujo a common name?
I barely recognize it. It seems way less recognizable than Scooby. Let's say Scooby, right? Scooby's Hot Dog Hut. Okay. Now I know I've heard of Scooby-Doo. It's a dog cartoon. Yeah. I can picture him right now. Let's say they, right? Yeah. Okay. Oh, you're doing it. Okay, so I'm horrible. So let's say you just use the word, right? Nothing about that kind of 1970s picture. Nothing about the coloring. No pictures of the dog. Just the name. You're saying that's too close. You're saying don't do it. Don't bet your company on it.
Don't bet your company on it, right?
Okay.
The way that this thing works is that these companies with big IP, like Scooby, like Mickey Mouse, I mean they literally have attorneys just looking for trademark infringement, whether it's at the USPTO, whether it's on social media, whether it's on literally they're going through on a monthly basis looking for infringement and sending cease and desist.
Okay, I'm going to push a little bit harder. I'm going to push one more notch further, Matt. So what would that opposition look like? How would they articulate their trademark rights in Scooby?
So they would say that they have, they wouldn't. I don't think they would call it a famous mark. but they would say it's like near famous, right? And they would say that it's a coined name. And because it's coined, it's given broader scope of protection, and that you're creating a false sense of connection between your use of the word Scooby and this brand, right? Because I'm sure that they have, they probably have entered into licensing deals for Scooby snacks, right? So they're probably on fruit snacks, right? They probably have lunch boxes. So they're closely associated with food services already. And they might even have licensed it for use on, food related services in the past. So
okay, awesome. That's good stuff. That's good. Okay, I'm gonna open up a new law firm, Scooby's Law Firm. Where are we at on that? On the fence, gray. Still don't do it.
We're on the fence about that one.
Cool.
Yeah.
Thank you. That's awesome. I peppered you with questions. That's a great answer. Thank you for that question, by the way. That was awesome coming out of.
I don't know if it's a great answer. There's no bad question, just bad answers. And I'm not.
No, you answered it well. You covered it, and then you gave it kind of the final, which is no, don't do it. Just don't.
Yeah.
Cool. Right on. Well, that's the end of our time together. Matt, thank you always for being on as co-host with me. For Matt and I, we're going to say goodbye from Bold Patents. If you miss us this time on live and you want to catch us next week, Wednesday morning, 9 a.m. Pacific and noon on the East Coast, we'll be here. We'll see you next week, everybody. Have a good day. Go big, go bold.